matter of Ibhawa versus the New York State Department of Human Rights.
Good afternoon. May it please the court, Donna Milling and co-counsel Roseanne Johnson for appellant Victor Ibhawa. Appellant would like to set aside 10 minutes for rebuttal.
Are you sure you want that much for rebuttal?
8 minutes?
It's unusual, but if you would like 8,
It is.
that's fine.
I understand that, Your
Yes.
Honor, but
We'll save you 8.
I'm going to err on the side of caution.
Fine.
Thank you. On April 21st, 2020, Father Victor Ibhawa, a Catholic priest assigned to the Blessed Trinity Church in the city of Buffalo, feared for his safety as he was verbally assaulted by a coworker who yelled racial slurs and profanities, including the N-word. Fearing for his safety, Father Ibhawa...
Counsel, we accept your factual allegations for purposes of this motion. So,
Thank you, Your Honor.
why don't you go into the issue of whether or not, given those allegations for purposes, again, only of this stage of the proceedings, why that doesn't fall within the ministerial exception?
Well, both DHR and the diocese rely on Hosanna Tabor, Our Lady of Guadalupe, which, as I'm sure this court is familiar, has nothing to do, did not apply the ministerial exception to hostile work environment claims.
And how would you square allowing a hostile work environment claim to go forward with those cases? What would be the rules around proceeding with a cause of action like that?
Well, I think, first of all, we're talking about, we're not talking about federal law, we're talking about the human rights law, the New York State human rights law.
Well, we're kind of talking about federal law too, and whether or not the Constitution limits what you can do. But if we were to say the cause of action for hostile workplace could go forward, do you think we would have to put any guardrails around the type of proof that the court could consider in letting you prove that claim?
Well, I would think that, you know, obviously an investigation would have to be conducted by DHR. You would have to look into the nature of the claim. And if you look at the human rights law, which is supposed to be narrowly construed, both the Supreme Court and this law, there's no exemption for religious institutions.
Well, let me ask you this. I understand your position to be the U.S. Supreme Court has left an open question as to whether or not this exception applies to hostile work environment claims. Okay. Your position is the ministerial exception shouldn't apply to hostile work environment claims. So let me ask you this. Is that sort of all hostile work environment claims? Is there a way to carve out certain hostile work environment claims? What's your, it might be closer to Judge Garcia's question, what's sort of your limiting principle?
I guess maybe I'm not understanding, but claims of discrimination.
Well, let me try this.
Yes.
Are there certain types of hostile work environment claims that might very well implicate what is at the heart of this ministerial exception?
I can tell you what doesn't. So
Okay, well, we can start with that.
Discrimination, racial
Yes, but if the
slurs, xenophobia.
discrimination is just termination, you say that's not, the basis for termination is discrimination, you say that's not covered by the exception?
But the ministerial exception, it has been applied under Hosanna Tabor and Guadalupe to hiring and firing.
Right.
They have not applied it to a hostile work environment.
Did you make a hostile work environment claim that is clearly separate from the termination claim?
Yes, we
okay,
did.
and where in the record will I find that and whatever allegations there are that
I
make that
believe
clear? I know you have allegations regarding the nature of the treatment, but
The allegations are laid out in the record, I believe it's pages 9 to 12 and
Right.
42 to 43.
But where is it clear that you are raising, I think a hostile work environment claim unless you're arguing constructive discharge, is different from a termination claim, right?
That is correct.
So where can I look to see that you are alleging two separate claims, one that's termination and one that is, I think you checked.
It's in all the pleadings, Your Honor. And if you look at the lower courts.
I think, though, you checked a box saying that there was a termination of employment claim, but I wasn't sure that you also checked it was a hostile work environment claim. So I just want to make sure what the record tells us about that I'm looking at the relevant pages.
And I believe that those pages that I just
Okay.
cited to.
So 9 to 12
And 42 to 43.
Okay, and just to pick up on Judge Rivera's question, if I can, let's suppose that you have someone who is working for a religious institution, and let's assume that it's established that this person is a minister, and let's suppose that they bring a hostile work environment claim based on gender, and the defense is that under the religious doctrine of this religious institution, men and women are viewed differently, and we're treating you different as a woman because that is something that is embedded in religious dogma. Could you proceed with that claim under Hosanna Tabor?
I don't think so, because I think as they talk about things that promote the tenets of the church and the faith, racism, xenophobia, discrimination, as far as I know, I'm a practicing Catholic, do not promote the tenets of the Catholic faith. And nobody has asserted that
Does misogyny?
it does.
Does misogyny?
Promote the
Does
tenets of the
misogyny?
Catholic faith?
Yes.
No. Not
The inferior status of females?
I'm sorry.
The inferior status of females? Vis-à-vis men?
Well, I mean, as far as the tenets of the faith,
Yes.
we are treated differently. Yes,
Yes.
I will say that.
Okay.
Yeah. So I guess what I'm trying to distinguish here is the fact that things that promote the faith and things that are involved in the organization and the hiring and firing, who to hire, who to fire, and to choose its ministers are different from, the noose over the door or the N-word scrawled on the wall. So just because you're a minister, if this decision is allowed to stand, what you're saying to religious organizations is, have at it. To religious employees, sorry, there's nothing we can do to help you. The First Amendment says that there's nothing we can do. I know the human rights law says that New York has some of the, I think, the strongest law, anti-discrimination
But I
laws.
think their argument was there is some recourse within sort of the tenets of the faith, right?
Within
First of
canon
all,
law.
they say they don't, right? I mean, the
Yes.
argument is, no, we don't in any way sanction what has been described in the complaint. But I thought they said you have a vehicle within the Catholic Church, or he did, I'm sorry, your
Yes.
client did.
But that has nothing to do with whether or not DHR has jurisdiction. And yes, let's say that there is a remedy in canon law. New York State says that you can choose to file your complaint anywhere. You don't even have to go to your employer and report the discrimination. You can go straight to DHR and file your complaint. So even if there is a remedy in canon law, he tried. He made several attempts. He told them what was going on. And instead, when he met with the hierarchy at the diocese, he was subjected to xenophobic statements. Oh, things are done differently here. Stories about priests who urinate on lawns, stories about priests from places who come to the United States and don't even know how to use a washing machine. And not only that, if there is a remedy under canon law, he was never accused of anything. Nobody told him, this is what you did in violation of canon law. He kept asking, what did I do? Why are you firing me? So to say now that, there's a remedy in canon law, the same place.
Is he seeking to be returned to this parish?
I'm sorry.
I'm sorry. Is he seeking to be returned and reinstated at this parish in the same position he held?
Your Honor, to be honest, we have not spoken about that remedy. We haven't looked that far. We're just dealing with what happened to him, and to now say that canon law is a remedy is...
Well, you must have some sense of the remedy he's looking for.
Yes, he's looking for, we're asking that
Yes.
this court reverse the Fourth Department's
Yes.
decision. He just wants an investigation of his claim by DHR,
Yes,
which
in
is
the-
what
in
they're
the hopes of-
mandated to do.
Okay, but the investigation, if indeed there's probable cause to find discrimination, what remedy would he be looking for?
Well, if he had been an employee at Walmart or
Yes, yes,
Xerox,
yes.
they would have processed his claim,
Yes.
conducted an investigation,
Yes.
and based on these allegations, I would imagine sanctions would be imposed against the employer who subjected him to this type of discrimination and hostile work
Some
environment.
remedy perhaps short of being reinstated and
Reinstated.
reappointed
Yeah.
at this particular parish.
That is correct, Your Honor.
Counselor, do we have to defer to DHR, in your opinion, in any way, their interpretation of the ministerial exception?
The cases from this court and everywhere else other courts have said that deference is to be given. And we understand that deference is to be given. However, deference is not unlimited. And when DHR makes a decision that has no legal precedent, there's no controlling authority, then deference shouldn't be given here. For example, I was a prosecutor.
But do they get to make, we have to defer to their legal determination?
No, you don't. And as a matter of fact, I'm sure this court is familiar with what the Supreme Court did in the Chevron doctrine. There's no more Chevron doctrine. In Loper-Bright, the Supreme Court said, we're not going to defer anymore when it comes to interpretations of the law and a statute. And this court is free to do that.
So, counsel, do you want to revise your answer to the previous question? It sounds to me like you're saying we don't owe them any deference with respect to this determination.
Well, with respect to this determination.
This one.
But in general, yes.
Yes, we all know that there's a rule that we defer to administrative agencies under certain circumstances, but we also have rules that define when we don't have to give
Right,
deference.
and especially-
Which one is this?
The general case law says that deference is to be afforded agencies because this is what they do every day, and they get a chance to, they're in a better position to do this. But those are cases where a hearing was held. We didn't get that far. They immediately looked at this, saw that the person who was alleging this was a priest, and said, oh, color, First Amendment. We can't look at this. So we didn't even get to a hearing.
So we don't know their legal conclusion any particular deference.
That's correct, right? I mean, I think they dismissed it for lack of jurisdiction.
Exactly. They conflated it. They saw the retaliatory firing and the hostile work environment. They conflated it, saw priest, and said, sorry, we can't help you. Yes.
Thank you.
Thank you, Your Honor.
If it please the court, Aaron Waskoff for Melissa Franco, General Counsel, Division of Human Rights.
Counsel, I know you don't have a lot of time, but I just want to ask you a couple of questions about the determination, if I can. The first is, did you understand the determination to be covering a hostile work environment claim as well as a termination claim?
Yes.
Okay, and so you think that there is a hostile work environment claim separately alleged? I was looking at the page of the record where there are boxes to check, and there is a box for harassment that's not checked, but you think it's adequately presented, I take it?
It's all-encompassing.
Okay. The second question I have is this. There was a statutory exemption that was included, I think, here, right? 298, I think it's subsection 10 or 11. You'll I'm sure, know which one. Why is it that the agency chooses to decide what I think is an open constitutional question, which is whether or not the ministerial exception applies to harassment claims, instead of first starting with a statutory exemption, which I think is generally the order in which, you proceed with legal analysis?
I can't explain why the investigation went that way.
I mean the decision, not the investigation.
That is what the regional director decided.
Does the agency generally consider, I looked to see how many cases there are that I could find applying the statutory exemption, and I didn't see many of them. Does the agency generally, look at the constitutional question first?
I'm not familiar with the agencies applying that human rights law exemption.
But do you think they could? It looks to me like on the text,
Definitely, it would have been available.
okay.
And I'm curious why you think of this as a jurisdictional issue. Let me start this way. I would think that the ministerial exception is in the way of an affirmative defense. Does that seem reasonable?
Yes.
And so that the minister would have the burden to prove that as an affirmative defense. Well, sorry, you would have the burden to prove it, right, against the allegation of the plaintiff, right?
Right. The issue was
Diocese would.
raised by the respondent
Right.
before the division.
Right, and so the burden would rest there, right, on the person asserting the affirmative defense. And ordinarily, you wouldn't treat that as a jurisdictional issue. You'd say, we have jurisdiction, and now we have to hear the affirmative defense.
Well, it becomes a jurisdictional issue because the reading by the division of the ministerial exception is that it precludes government interference in the rules, regulations, and policies of internal management
But I
of a
think-
religious
To
organization.
the
thought that-
Chief Judge's point, I'm sorry, here, to the Chief Judge's point on that, I think the Supreme Court has said exactly what he just paraphrased, which is, this is not jurisdictional, this is an affirmative defense. So how can you dismiss it before they raise the affirmative defense, and we don't have a record of what type of proof would be necessary to prove or disprove these allegations, and whether or not you really would have to get into this type of
During the course
inquiry?
of the investigation, it was raised by the respondent, and we're commonly looking at matters that involve religious organizations where the ministerial exception does come into play. While
Yes, there was no fact-finding, is that correct?
the fact-finding was to the extent of both parties agreeing that this individual was the pastor of this congregation.
And then that removed this from your agency as a jurisdictional matter.
That's our position, that we're not allowed to interfere in their internal management, that they had avenues within their organization for this to be dealt with, and
So
we're not
that
to
that
interfere.
includes, of course, termination, right? But that includes this question that's been left open by the U.S. Supreme Court about hostile work environment?
Well, we were taking a reading of Hosanna and Our Lady of Guadalupe that sort of pushes the government out of
I have
management.
to say, I was a bit surprised by the division's approach. One would think such an open question that has divided other courts with no decision from us, that there would be perhaps some actual extensive analysis provided by the division in support of its determination. I mean, did I miss it? Was there some analysis in this
Well,
record?
Basically, once the parties were in agreement that it
Yes.
was a pastor, and they both were in
Yes.
agreement of that, we
Yes.
saw no factual issue to be
But
determined.
there's an open legal question, right? I mean, the circuit courts have split on the question of whether or not, even once you determine that the individual is a minister, it applies to a claim like this, which is harassment, not termination. And as Judge Rivera says, I don't see any exploration of that question in the decision.
Because the division halted when both parties agreed that it's a pastor.
But
and
that
we're not
doesn't
getting-
answer, even if the person is, even if the person is a minister, I think that still leaves open the question of whether the exception applies to this kind of claim. Isn't that what's circuit?
Yeah, that's why we're here.
Yes, but that's the point. One would have thought, again, because there is no controlling authority in New York on this issue, and the U.S. Supreme Court has left it open, that the division would have given its opinion in some kind of writing even if it was in some conclusory fashion, that one could clearly understand how you had reached this conclusion, how you had reached this particular determination. It might have been, shall I say, at the least helpful for our analysis here.
Understood, but the determination does make clear that we are of a position that we are not to interfere with internal management of a religious organization.
So then we should, just to be clear on your representation, it should be our understanding that this decision is the division's conclusion that the ministerial exception applies to hostile work environment claims? That's what we should take from this decision?
I would say we don't even get to that because this is an action under Human Rights Law 298 and for judicial review. And under judicial review, if there is a rational basis for the determination where we're following the ministerial exception.
But I'm just trying to confirm the basis for the determination.
The basis for the determination is that the ministerial exception under Demkovich, Hosanna Tabor, Our Lady of Guadalupe, leads us to.
Applies to this claim.
Yes, in that we shouldn't interfere with internal management of a religious organization.
And just so I'm clear, including hostile work environment. It applies to hostile work environment.
Yes.
But their decision also has to be made without an error of law, right? An error of law at the administrative level will lead to a reversal. And if you're saying it was jurisdictional in the Supreme Court, it says it's not jurisdictional, why isn't that an error of law?
The Supreme Court has not said.
I think if you look at footnote 4 of Hosanna Tabor, it does say it's an affirmative defense. And so if we were to conclude that that is an error of law, it seems to me we would need to send it back.
The issue was raised by the respondent before the division.
Thank you.
Okay, thank you.
Good afternoon, Your Honors. Kathleen McGraw, Bonchenick and King. I'm here with my co-counsel, Aaron Torsello, on behalf of Respondent Diocese of Buffalo. I'm going to jump right in on this topic we were just discussing of the affirmative defense issue. I think it's important to recognize the differences between an administrative investigation and complaint and, like, if you were to sue a case in state Supreme Court. Everything's determined kind of all at once, and the record is very clear in this matter that there was significant briefing back and forth by respondent, the diocese, and Father Ibhawa on these issues. And I do really think it's important to note that at the division level, a determination that it lacks jurisdiction is the same effect as if it had said we lack probable cause. There's two options under the regulations. You can say there's no probable cause to investigate this, or you can say we don't have jurisdiction. The effect is the same. So I agree with Your Honors, and footnote 4 in Hosanna Tabor certainly does say that the ministerial exception is an affirmative defense, but I do think that that's talking about in the Title VII.
Well, so just to be clear, it lacks probable cause. It's effectively the same when they say lacks jurisdiction because of the pure legal question as to whether or not the ministerial exception applies to a hostile work environment, or because you were persuaded that there was no hostile work environment here.
My statement
Not
that
you, I'm sorry, the division.
My statement that it's effectively the same is a matter of how it turns out practically. Practically, you get a letter that says your claim is dismissed. And
Sure, yes, of course, but that's not helping me.
And then, I'm sorry, what was your, I don't understand your question.
Probable cause determinations could be based on the law. You're not wrong about that. It doesn't deprive them of jurisdiction, but it could be as a legal matter. Otherwise, it's not a claim there. But they may very well be based on a factual determination.
Yeah,
So,
that's correct.
Is there any way for us to determine, based on what the division did here, which of those categories this falls into?
Well, it says that it's a jurisdictional dismissal, so I think.
No, I know that, whether or not it's purely about the law or there's any factual aspect to this analysis.
I don't think it's plainly clear on the face of the determination, but I do think that looking into the record and the briefing back and forth by the parties, there was really not a dispute of fact here. The diocese certainly reserved its rights with respect to some of the allegations, but this was all about the law. It was all about this unsettled constitutional law, and that's why the determination by the division, that's why I'm saying it would have.
Except that doesn't exactly square with what we just heard from counsel for the department, which is that as soon as they heard a priest was involved, they stopped. That was dispositive. So all this rest of the briefing back and forth about whatever seems like it was irrelevant to the department's decision.
I wouldn't, respectfully, I'm not the division, I don't know, and I think I would disagree, because I think this case went beyond the typical briefing that you would see back and forth by the parties. And I don't think that it was just priest, hang up the phone, they're out of luck there. We talked a lot about, and this is where the allegations of hostile work environment really came out, and, the box was not checked, that is correct, but we treated this as if it was a hostile work environment claim as well as a termination claim, and briefed both legal issues.
But none of that is reflected in the determination from the agency, right? It's one sentence.
That it is one sentence. There is also in the record, and I apologize, I don't have the exact pages, but there's another internal determination that I think is in the formal
Right,
division.
which is a couple pages, I think.
Correct.
But I don't think dives into the substance of the open constitutional question. Let me ask you another question, if I can. Do you agree that the statutory exemption could be applied here?
I think it could be applied. I don't think that it needed to be. And I will note that based on my research, 296 and its sub 11 has not been applied to an employment claim since Hosanna Tabor. I do think that it certainly predates it on the books, and I don't think that
But do you think that Hosanna Tabor means that for some reason it couldn't be, or simply that it hasn't been?
No, I don't think that it means it couldn't be. I do think it has to be, 296.11 would have to be applied consistent with Hosanna Tabor and Our Lady of Guadalupe.
What's your view on the idea of a remittal to resolve a non-constitutional basis for this determination before getting to the constitutional one?
I'm sorry, I don't understand.
Should it be remitted for a determination of whether an exemption applies before we even tackle this constitutional issue?
I don't think so, because I think that the determination by the division that it didn't have jurisdiction based on the ministerial exception has to be accorded significant deference and is not arbitrary and capricious. I mean, the standard here is very high.
So we could address it on the merits?
I'm sorry.
We could review on the merit, make a determination on the merits here?
I do not think that this court even has jurisdiction to review the merits of the division's dismissal. We are.
Now
Wait, you mean
I
that-
really don't understand, because if your view is that the jurisdictional decision we got, says there's no jurisdiction, is based on the division's interpretation of constitutional law from the Supreme Court, setting out the ministerial exception, why we can't review that?
This got to the trial court on an administrative appeal. So the standard on the initial trial court decision was, did the division act arbitrarily, capriciously, or in error of law? That determination by the trial court.
And if it misinterpreted United States Supreme Court law as to the scope of the ministerial exception, that seems like that would be an error of law.
And I don't think there's any,
The question isn't whether we should reverse, the question is whether we can review.
and our position is still that there is not a constitutional question here. That was never.
Even though the constitutional question is the basis for the no jurisdiction decision.
Yes, but again, it's in the administrative appeal context, so you're coming at it without.
Counsel, I'm having a hard time understanding that, because it seems to me that, and I think that counsel for the agency's comments confirm this, there are some number of cases that come before the agency which involve someone who is perhaps a minister and could invoke the exception. And this is a question that's divided the federal courts, right? And so I think if your position is correct, that means that no court can review the agency's determination on an open question of constitutional law?
Let's say they
How
went
could
the
that
other
be?
way from you. What if they decided it the other way? It would be
So-
the same position?
I actually don't think so. So I think the question here is, if
If you
it had.
lost, we could review.
Well, so let me say, so if it was decided the other way, if it was decided that they were going to investigate because they determined that the ministerial exception did not apply to harassment claims, We, the diocese, would have made the same administrative appeal, and in that circumstance, the posture would have been, we believe our constitutional rights under the First Amendment are violated, because now we believe that the state is entangling and impeding our free exercise.
So only someone claiming an Establishment Clause claim can vindicate the rights that are set forth under Hosanna Tabor and Our Lady of Guadalupe? I don't understand how only the religious institution and not a plaintiff could vindicate those rights in a court of law as opposed to the agency.
So certainly, Father Ibhawa could have brought this case in trial court. He could have sued this case in Supreme Court.
I understand, but what I think you're saying is that if you go to the agency first, that only the religious institution can go to court to get review of the constitutional question and not the plaintiff. But maybe I'm misunderstanding you.
I'm not saying that. I'm saying that he went to the agency, so then the agency's determination must be afforded deference, one way or the other. And I'm not saying we would be I'm sorry, go ahead.
So maybe I misunderstood you. I thought what you said is that if someone goes to the agency, that if the agency invokes the ministerial exception, that plaintiff cannot appeal that up through the courts, cannot appeal the determination on the constitutional question up through the courts, but that if it were an adverse decision against you, you could appeal that. Is that right?
What I'm saying is that...
I'm sorry, I'm just looking.
The answer
do I understand
yes,
you?
yes. But what I'm saying is because Father Ibhawa's position and the diocese position are different, he's not claiming that by the dismissal that his constitutional rights are infringed. He's claiming that you didn't investigate my employment discrimination claim. We're saying that what I was trying to explain was that if the diocese was in the reverse posture, our argument wouldn't be that the division didn't do its job, it's that our constitutional rights are infringed. And just to be very clear, what I was arguing on the jurisdiction of...
But if the reason they don't do the investigation.
I'm sorry?
If the reason is they don't do the investigation because they believe you have particular constitutional rights that would be infringed upon by such an investigation, you can't challenge that, and that wouldn't raise a constitutional issue?
You can challenge it under the arbitrary and capricious standard. I don't think that it raises the constitutional issue. I do think it's really important to note here, this isn't a question of, there isn't United States Supreme Court or any controlling law saying that the ministerial exception does not apply to harassment claims. The division sided one way of the circuit split over the other. I do not think that that is possibly any error of law.
How do we know they did that?
I'm sorry?
How do we know they did that?
Because they decided that they dismissed the entire claim, which included the hostile work environment claim, thus aligning.
Is it possible they thought this particular claim had no basis in that hostile environment work jurisprudence, or that he didn't make it out? Is that any of that possible, or no, not at all?
It's possible. I wasn't the agency, so I didn't make that determination. I don't know.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Erin Torsello of Bonchinick and King. I want to thank you for allowing both of us to present today.
On behalf of the court, I just wanted to say it's an unusual request. We don't usually let parties split time, but we would like to encourage the practice that you have asked for, which is to allow a younger attorney to have an experience of arguing here.
Thank you. And I'm obviously the younger attorney, correct?
You got me.
It's certainly a hard call.
Thank you. One of the topics that Your Honors have touched upon is whether or not there is a way when analyzing these hostile work environment claims, whether or not you can do so without infringing upon the church's right to free exercise and avoid infringement within the internal governance of the church matters. And it is our position, following Demkovich, along with Hosanna Tabor and Lady Guadalupe, that that is not possible. My counterpart raises her, talks about the allegations within the underlying facts in terms of the racial slurs that were stated. The racial slurs that were stated, the underlying facts in terms of the underlying facts in terms of the racial slurs that were stated. The racial slurs that were stated, the underlying facts in terms of 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 the underlying facts in it's important to mention that it's not just an employee, but there were also allegations about a parishioner also making xenophobic.
Do you want to address, counsel, why you think that the Seventh Circuit has the better of the view as over the Ninth Circuit?
Yes, because the role of in this case, a priest or a minister, their role as an employee, is intertwined with their role as a minister.
Would that be true then only for someone who is a priest? I mean, I think the Seventh and the Ninth Circuits articulate different frameworks for dealing with harassment claims. So why should we, I take it you support the Seventh Circuit's view?
I do support the
And
Seventh
why?
Circuit. Because the Ninth Circuit created a test that talked about tangible versus intangible employment actions. And you could only, the ministerial exception applies only to the tangible employment actions, not intangible employment actions, meaning your interaction within the workplace. The Seventh Circuit's decision is instructive. First of all, it's post-Hosanna Tabor, so it's taking into account the reasoning of Hosanna Tabor that says, as well as Our Lady
Do you
Guadalupe.
think the Ninth Circuit's decision can't survive Hosanna Tabor?
Correct.
And why is that exactly? What in Hosanna Tabor bears or precludes the Ninth Circuit's ruling?
Sure. So Hosanna Tabor, in the court reasoned that the religious clauses of the First Amendment ensures a church or a religious employer has the autonomy to select and control its ministers in order to minister to its faithful. Similarly, in Our Lady Guadalupe, the court observed that it was important for the church's independence on matters of faith and doctrine that the church have the authority to select, supervise, and remove, if necessary, a minister. Those two reasonings within those two decisions absolutely support the contention that hostile work environment claims, because it's dealing with supervision and control during the time of employment.
But if the reason for the different treatment is one that is abhorrent to the faith, how does it then fit under the Supreme Court's underlying analysis, which is, I know what you're arguing?
Sure, I understand. So the issue is, because in a hostile work environment claim, there's two segments to that analysis. The first is whether or not the conduct was harassing, and there's a standard for that. Let's leave that aside for right now. The second part of the analysis is whether or not there's liability to the employer. That is the problem. That part of the analysis is the problem, because we're under the human rights law, so I'll stick with that standard, which has changed, so I'll make it easy to say the New York State human rights law, in order to create liability on the part of the employer, there has to be a burden of proof to show that the employer condoned or acquiesced in the conduct. So taking the situation with Father Ibhawa, Councilor Millings was addressing the fact that he went to the diocese, and the diocese responded and said, and this is in their papers, the diocese did not take any action and told him in part there are different ways in ministry and serving people. So the question is will liability attach there, because the church, the diocese is telling this priest, you should not have handled it the way you handled it.
I don't quite understand how liability intersects with their established right to hire, appoint, supervise, if the liability is viewed simply as a consequence of what a plaintiff, like the minister here, dealt with when they arrived in the workplace.
But an employer is not automatically liable just where there was, even where there was conduct
I
that was
understand that it
harassing.
has to be condoned in some
Yes.
way or not addressed,
Yeah, either
at the
not-
very least.
Right, so.
But that still doesn't implicate the rights to appoint or hire, does it?
Well, because the division or a court would have to say, well, the diocese response to say, you did not minister in the correct way
But
in
those are all
dealing.
factual issues. I wasn't even asking you about the factual, they didn't do an investigation.
But- I understand,
It
but
may
that,
very well be, if there had been an investigation, the division makes the exact findings that you're advocating for.
Mm-hmm.
But I can't see that in this decision that they've made. So I was asking what I thought was a pure legal question. Perhaps it cannot be answered as a pure legal question. I'm trying to understand how if the conduct that creates the alleged hostile work environment is conduct that is contrary to the dogma, the tenets, the principles, is abhorrent to the Catholic Church, how nevertheless that somehow is protected by the ministerial exception. As a large theoretical question, not as whether or not he could make his case.
Sure, the issue, and my light is on, so I want to respect
Please
the
go
court's
ahead and
time.
answer. Thank you.
But the factual issues are so intertwined with his role as a priest, it cannot be answered on a legal basis alone, because the facts,
Can I ask you one? I know your light's on too. I appreciate you noting that, but one last question if I can. Is your view that if we were to decide there was an error of law because this was treated as a jurisdictional matter and not an affirmative defense, that you could, upon return to the agency, invoke 296.11, which I think you did?
That's a good question.
Well, you did rely on it, I
Yes.
believe. Is that right?
Yeah.
So is there a reason? I thought that you raised it as a defense, but.
Right, because we can choose who our minister, yes, that's correct.
And so is there a reason that you couldn't pursue that defense on a remand, if that's where we ended up?
We could pursue that on a remand. I think we could also pursue the same issue on a remand if it's the court's position that they did not fully consider or give a rational basis for its dismissal on jurisdictional grounds. But it will be the same we made the same arguments. We made the affirmative defense arguments at the.
I understand, although generally I think a statutory question is different than a constitutional question, but in any event.
Thank you.
Thank you.
Your Honor, I would just like to briefly respond to, Judge Rivera had asked whether or not, who would set the parameters for discrimination as far as hostile work environment. It's our contention that the parameters are already set in Executive Law 296H, the anti-discrimination law. It sets forth all the unlawful acts, and we believe that that would fit under a hostile work environment. As far as checking the box, I believe we checked the box. If we did not, that is also not a problem. It's up to DHR to determine what claims may lie. This is a form that's filled out by regular Joe Smith without the help of a lawyer, and so the form is created that way. As far as the affirmative defense, I believe it was Judge Halligan who pointed out that Chief Justice Roberts, in his decision, where he said that Hosanna Tabor, they're not deciding whether or not Hosanna Tabor, the ministerial exception applies to anything other than hiring and firing. And then he goes on to say, in any event, it's an affirmative defense and not a jurisdictional, it's an affirmative defense, not a jurisdictional bar. And DHR, Mr. Waskoff, has said that the affirmative defense was raised by the diocese, and that is correct. They did raise it, but just because they said it doesn't make it so. I was a prosecutor, and if the defendant murdered somebody and he said, I'm asserting justification, but I'm not testifying and I'm not putting any proof on, well, just trust me, I was justified before I killed the person, that would be the same analogy. As far as...
But, I'm sorry, is this point that the division did, in fact, consider the affirmative defense and rendered a decision accepting it? Accepting it? Is that your position?
No, we don't know what they did other than saying that he's a priest, First Amendment, sorry, we can't help you. As far as the Seventh and Ninth Circuit decisions, while they might be instructive, obviously they're not controlling on this court. And I guess I can't emphasize enough that this is a New York State agency. This is the agency that is mandated by the legislature.
But counsel, the agency is subject to the U.S. Constitution, right? So
It is.
what do you say to the Seventh Circuit's general position that investigating alone violates the First Amendment prohibitions? Because in investigating, they would have to come in and justify and get into the reasons why they're doing this and not doing certain things, or stopping or not stopping certain things, and that would get into areas that should not be explored.
Well, at least they have to try. And I mean, this is not a hiring and firing. If somebody is alleging that I was called the N-word, or, you know, I'm being discriminated against in my workplace, I don't know how much delving you have to go into internal church management. And I would imagine that no church or religious organization is going to say, we condone discrimination, and so therefore we're not answering your questions.
I think we need a rule that would apply more broadly, right? And isn't the concern that many hostile work environment claims require you to get enmeshed in the management of a religious institution in a way that really treads on what the Constitution, you know, walls off?
I don't know about many. I don't see it in this instance. I'm sure it obviously, there are instances where that would occur. So maybe this would be a case-by-case basis.
So, you know, to take the example you were, sorry, over here, to take the example you were giving, you know, I can't imagine the diocese would say we condone our parishioners calling people the N-word, but they might say, we want to be the ones to figure out how best consistent with our faith, to deal with that problem. That is, we may want to tell the priest in this circumstance that he needs to turn the other cheek. We may want to have him counsel or have somebody else counsel the parishioner. And it's not that they would say, we condone this behavior. They may say, this is abhorrent, but we want to be the ones to police it, and the First Amendment gives us that right.
And we'll ignore the human rights law.
Well, it's not.
We understand that New York State provides you protections, but we're not going
Well,
to.
the question is whether enforcing those protections in this circumstance intrudes on their First Amendment right.
And our position, obviously, is no, it doesn't. The church, even the Supreme Court has said that the church is not immune from secular laws. They said it in Guadalupe, they said it in Hosanna Tabor. We can't have separate rules just because you're a religious employee. It can't be a free-for-all.
But clearly, if they fire a
Yes.
minister, but why isn't that the same argument? Well, that's the human rights law. You can't do that under the human rights law. How can you condone that? It's the state human rights law, and now you're saying somebody could get fired for improper reasons, and you can't even look at it.
Because I think, as you said, or I think Judge Rowan said, that Judge Wilson said, it's part of the internal governance and management of church doctrine. Discrimination is different. It doesn't promote the faith.
I discriminated against this minister and I fired them. That's not reviewable, right?
Well, it depends on the reason why you fired him.
No, I don't think it does.
I mean, it seems like a termination is, whether we think it's inappropriate, even abhorrent, a termination is shielded from judicial review, isn't it?
Under the ministerial exception.
Right.
Yes.
And so there are, to Judge Garcia's point, there are some employment actions that are
Yes.
taken where we don't, because the Constitution prohibits us, let a state agency take a look at. And so the question is just, why is the work environment and a harassment claim different in kind than termination? Because termination is off bounds.
And I think the courts have talked about tangible employment actions, and it all goes back to advancing the tenets of the faith and the church.
But that brings me back to Chief Judge Wilson's hypothetical. What if they view their response to this hostile work environment situation as a doctrinal issue? We want to minister to the people who are doing this. We want to teach our clergy member that he needs to be more forgiving the
Yes.
way Jesus was.
Right, do what Jesus did, yes.
So, how do you separate, how do you pull out what's ministerial and what's not?
Well, I guess they're going to have to decide that, what you're saying then is that the church is going to be saying, listen, you're a religious employee, you have no civil rights, okay? You're going to do what Jesus did, and you're going to turn your cheek, and no matter what is done to you, look to the Bible.
Well, it may
and
not
look
be,
to Jesus.
it may not be, maybe it's turn the other cheek, maybe.
Yeah.
But maybe it's some other way of dealing with the situation. And so let me go one step further with these questions. What if you had been successful and the division orders a sanction, a particular type of sanction that the church finds offensive to its tenants, might indeed put a wedge between the ministers, the church, that parish, and the flock? How is that not about government telling them how to handle and manage the issues that arise within their ministry?
Because I think a line has to be drawn, and then I guess it'll be up to the legislature in New York State to say there's an exemption for racial discrimination, harassment, when it comes to religious organizations.
In this case,
and
it's really
religious
about the U.S.
employees.
Supreme Court and the federal Constitution, right? I mean,
Yeah,
Thank you.
thank you, Your Honor.